When Rebecca Walker, Smith's girlfriend, who was serving out 10 years as an accessory, testified during trial, it was shocking as she revealed she both encouraged him to kill his family so they could be together and was on a video call while he carried it out.
I did encourage him by telling him to hurry up and do it.
But later on in her testimony, what Walker would say would eventually snowball into grounds for appeal. Attorney John Sullivan, who was representing Smith, asked Walker what she would have been sentenced to if she was still charged with the murders and hadn't taken the deal with the prosecutor's office to testify against him. At first, she said 20 years, but later corrected herself to say life. Former Assistant Prosecutor Don Morris then pointed out that by asking her this, they've now implied Smith would be looking at life too, and asked the jurors be given instructions that because they were teens, Smith would get to see the parole board in 15 years. The defense in that moment was fine with that, and this was a key part of the argument from the state in favor of affirming the case before the Supreme Court in January.
Petitioner was the one who introduced the issue of sentencing into this case, and petitioner then agreed to an additional instruction from the court to address the confusion that petitioner himself invited.
But even though defense was fine with it in that moment during trial, it became more confusing when the state asked that there be more clarity on this in the jury instructions, worried that the initial guidance from testimony would be confusing for the jury. Smith's attorney then objected to this, arguing that the jury should only be considering facts of this case without sentencing in mind. Judge Ken Ballard overruled the objection and gave them instructions about sentencing and parole. Matthew Brummond, who represented Smith in front of the Supreme Court, said this was why they filed their appeal, as it created prejudice against Smith.
That's what makes this error so prejudicial. It is much easier to condemn a young person to prison under a first-degree murder conviction for first-degree murder convictions if you think that your verdict won't be the last say.
And the state's highest court ultimately agreed, despite arguments from the state that the case and trial were so high stakes that the jury's decision shouldn't be thrown out based on something the defense brought on.
As a defendant who, over several days, over several conversations, over a long period of time, is making careful, deliberative steps to brutally murder his parents, execution style, and then seek out the only two remaining victims in the house and kill them as well. And I think given that overwhelming evidence, it just isn't the case that the tiny delta between the agreed to instruction and the closing argument instruction is enough to actually say there's a question about the viability of this jury's verdict.
Justice Armstead did side with the state in this and dissented against the majority opinion, arguing that the state and court's efforts to remedy the confusion was reasonable. The other justices felt otherwise, that placing sentencing matters before the jury was a reversible error that does not mean acquittal, but does require a new trial.